So this way, what we'll be looking at is the topic on corporate constitution. Okay? Apology for the typo error there, right? Should be lecture 4, 5, sorry. So by the end of this lecture, okay, what you should understand, what you should know is, well, what is the legal significance of a company's constitution? So we'll be looking at what are model articles of association. How are the articles applied in a company vis-a-vis members and a company? What is its legal nature, significance? And how is the internal management of a company and how it can be altered? So how can an article under the Articles of Association can be altered? And what if, as we'll look at later on, right? What if the majority shareholders uses an amendment or alteration of the articles to oppress the minority? Is there anything that the minority shareholders can do? Now, first of all, okay, what is a corporate constitution? Now, generally speaking, when we say corporate constitution, right, we are usually referring to the Articles of Association or model articles of a company. Now, what that does is, generally speaking, okay, it sets out the so-called internal management rules of a company. So, for example, if there is a dispute between shareholders, how do we resolve it? Well, you first look at the articles. If there is a dispute between the company and the shareholders, how do we resolve it? Well, we look to the articles as well. Historically, okay, the Articles of Association, the corporate constitution also contains the object of the company. That's not important anymore. So it mainly sets out the powers, rights, and duties of a shareholder vis-a-vis a company. This, that which includes the appointment of directors and officers. And what procedures do you need to take if the shareholders want to amend the rules under the Articles of Association? Now, if you set up a company, what usually happens is, right, in order to save time and cost, okay, what it allows you to do is to adopt what we call a model or standard form of Articles of Association. Now, of course, once you adopt that model or standard form of Articles of Association, then it is up to you, the shareholders, to amend it or to alter it for your own needs. But in order to save time and cost, okay, what most companies do, especially if you're SMEs, right, you will simply adopt the so-called model articles or standard form Articles of Association. Now, it includes, right, the mandatory articles include, right, company names, company's objects, the liabilities of members, the shares which the shareholders have agreed to subscribe to, okay, share capital. Now, it used to be the case in Hong Kong, okay, if you set up a company, right, there's a minimum capital required, okay? Now, that has since been abolished. And in the past, in England and Hong Kong, there is the so-called Memorandum of Association, okay? Memorandum of Association. Now, but that has since been abolished in both the UK and Hong Kong. Now, basically, okay, the policy, the public policy today is, right, the Articles of Association, okay, in theory, should be kept as simple as possible. And reason for that, okay, is of course to encourage investment, especially for small, medium-priced enterprises. Right, so in other words, we just take an article off the shelf and apply that as your standard form model articles for most companies. So what is the legal significance of a corporate constitution, of articles of association? Now, section 86 subsection 1 provides that the corporate constitution, the articles of association, have the effect of a contract, number one, between the company and each shareholder, and number two, between each shareholders themselves. So amongst shareholders themselves. So it is a contract, okay, between a company and a shareholder, or shareholders, and a contract amongst shareholders themselves. So basically it is, if you like, a covenant, okay, between the company and its members. So for example, right, some articles of association would contain what we call, as we'll look at later, the right of preemption. In other words, if the existing shareholders want to sell their shares, they must first offer it to the other existing shareholders at a fair value before offering it to an outsider. Now, this was first illustrated in a case called Hickman versus Henry Sheep Breeders Association. Okay, so a contract between the company and each shareholder. Now, what happened in this case was the Sheep Breeders Association was registered as company, and all the members, okay, were regarded as shareholders in the capacity as shareholders. Now, what happened was Article 49 of the association's model article provided that dispute between the association and the member or shareholder shall first resort to arbitration before going to the court. Now, Mr. Hickman, the plaintiff, was a member and shareholder of the association, and he complained that the association, for some reason, refused to register his sheep in the published flock book. Okay, so he complained, as a member, shareholder, he complained that the association, for some reason, refused to register his sheep in a flock book. And he was also, at the same time, under threat of being expelled from the association. So what he did was, he then decided to bring a proceeding in the High Court. And in return, the association wanted an injunction to stop him from bringing the court proceeding. Now, the court ruled in favor of the association and held that the Articles of Association acted as if there is a contract between the association as a company and each member. So as a member, okay, or shareholder, Mr. Hickman was therefore bound to comply with the procedure. In other words, he was bound to bring the disputes to arbitration first before going to the court. So in other words, right, this shows the principle, right? The Articles of Association, or the rules under the Articles of Association, okay, is like a contract binding the company, in this case the association, and members. Now, this was also illustrated in the Hong Kong case called Kenneth Ng versus Hong Kong Football Association Limited. Now, the Football Association was also registered as a company. Now, what happened here was the plaintiff, Mr. Kenneth Ng, he was a football referee and a member of the Football Association. Now, subsequently, what happened was he got into a dispute with the association, and the council of the Football Association made a decision that the plaintiff, Kenneth was unwelcome to take part in their activities, or to register himself as a referee of the association. Okay, so the Football Association, the Council of the Football Association, made a decision that Mr. Kenneth is unwelcome and refuses to register himself as a referee of the association. Now, the plaintiff, Mr. objected to the decision, and he issued a court writ claiming that the decision of the council was invalid. In return, the association applied to the court for a stay of proceedings, in other words, to rule out the court proceedings, by relying on its article of association, whereby differences between members were subject to the decisions of the council and not the court. Now, the High Court denied the request of the Football Association for the stay of proceedings, on the ground that Article 49, in other words the relevant article of the association, did not make any provision for arbitration of disputes between the association and its members. In other words, what the court is saying, right? Regulations 49 of the Football Association only provided that differences between members was subject to the decision of the council. If it is a dispute between the members and the association, it is free for the party to resort to any form it wants, arbitration or court proceedings. Because what the regulation says, right? Disputes between members subject to the decision of the council. It doesn't say dispute between members and the association subject to decisions of the council. So in other words, Mr. Kenneth was free to choose whatever way it wanted to resolve the dispute, either arbitration, court proceedings, etc., etc. Now, apart from the fact that it is a contract, as I said earlier, right, Section 86, contract between the company and the shareholders, it is also a contract amongst members themselves. Now, this was first illustrated in a case called Rayfield versus Hanks. Now, what happened in this case was, Mr. Rayfield sued the directors of a company and wanted to force them to buy his shares. Now, Article 11 of the company's constitution said, quote, every member who intends to transfer shares shall inform the directors, who will take the said shares equally between them at a fair value. Okay? Every member or shareholder who intends to transfer shares shall first inform the directors, who will take the said shares equally between them at a fair value. Now, what happened was the directors, for some reason, refused to follow this rule, and Mr. Rayfield, as a shareholder, tried to seek for an injunction at the court to enforce Article 11. And the court granted the injunction and held that the article imposing obligations on the directors, not as officers, but also in their capacity as shareholders. Granted the injunction and held that the article, imposed an obligation on the directors merely not as officers of the company, but also in their capacity as shareholders. So it's a contract, right, between the company and shareholders, and a contract binding the shareholders themselves. Now, what if the articles provided a term whereby the interest of an outsider is protected? What are the articles of the term to protect the interest of an outsider? Can the outsider enforce the terms of the article? Now, this was first discussed in a case called Ely versus Positive Life Assurance Company. Now, what happened in this case was Article 118 of the company's constitution stated that Mr. William Ely shall be the solicitor to the company. Okay? Article 118 of the company's constitution stated that Mr. William Ely, the plaintiff here, shall be the solicitor to the company. Now, but the company, as it turned out, never employed him as a solicitor because there was no such need. Now, at the same time, the plaintiff, Mr. Ely, was also a shareholder of the company. So what he decided to do, he brought an action to enforce the articles in his capacity as a solicitor. So in other words, he was enforcing this article, okay, in the capacity as a solicitor, but not as a shareholder of the company. Now, what the High Court held was the articles did not create any contract between Mr. Ely and the company. And on appeal, the Court of Appeal affirmed the High Court's decision and held that Mr. Ely had the right to sue only in his capacity as a shareholder, but not as a solicitor. Or to put it simply, what the Court of Appeal is saying is, right, as an outsider, okay, you do not have the right to enforce the terms of the articles against the company. Now, why do you think this is said? Based on what principle? Sorry?
Contract.
Right. Privity of contract, right? Based on the doctrine of privity of contract under the Articles of Association. Right? Because the Articles of Association, right, under Section 81, right, it says it is a contract between the members and the company and among shareholders themselves. So in other words, you must be a party to this arrangement in order to enforce the terms, based on the doctrine of privity of contract under contract law. Now, another issue relating to corporate constitution or Articles of Association is, of course, amendment. Now, of course, as I said earlier, right, when you set up a company, okay, for the purpose of convenience, you can simply adopt a standard form of Articles of Association. Now, but as your company expands and develops, you would then realize that there are certain aspects that need amending. So the next question is, right, how do you amend an article? What legal procedures do you have to follow? Now, Section 80 of the company's ordinance provides that a company can be displaced, a rule in the model articles can be displaced, repealed, or modified by the company. Now, but in doing so, you will also need to follow the proper procedure. You either amend or repeal a rule in the articles, by an ordinary resolution, which requires a simple majority, i.e. 50 plus 1, or a special resolution, which requires a 3/4 majority. Okay? So ordinary resolution, simple majority, 50 plus 1, or special resolution, a 3/4 majority. And as we'll look at later, right? So what type of alteration or amendment simply requires an ordinary resolution, and what types require special resolution? Now, what are the limitations on the alterations of Articles of Association? Now, Section 92, okay, provides for the limitations. Now, Section 92 provides that members or shareholders are not bound by alteration affecting their rights and liability unless their written consent is obtained. Okay? Alteration affecting their rights and liability unless written consent. Okay? So, for example, right? Section 92, subsection 1A provides that, right? Members are not bound by the alteration if it requires them to take up additional shares. Okay? Members are not bound by the resolution or alteration of the articles if it requires them to take up additional shares. They are not bound either if they are required to increase their liability for capital contribution. Nor are they bound if the alteration is to increase their liability to pay more money to the company. So in other words, to put it simply, right, you cannot force, the alteration cannot force an existing shareholder to put more money or investment into a company without proper consent. Now, of course, as we'll look at later, okay, what the alteration or the most controversial thing about amendment to the articles is, what if the majority shareholders uses the alteration for their own personal gain? Supposing you're minority shareholders, you control, say, 20%. And then the majority shareholders with 80% control votes to amend a rule in the articles, which would eventually hurt your interests. Is there anything that you can do as a minority shareholder? Now, this was first discussed in a case, in a 1900 case, called Allen versus Gold Reefs West Africa Limited. Now, what happened in this case was the articles of Gold Reefs Company gave it a first and paramount lien on all partly paid shares by any shareholder for any debt owed to the company. Now, what happened in this case was there was a Mr. Zucani. He held some partly paid up shares, and he also owned the only fully paid up shares issued by the company. Now, subsequently, what happened was he passed away, and the shares were transferred to his estate. Now, what happened was the company then decided to alter its article by a special resolution to create a lien on all fully paid shares. In other words, to alter the Articles of the Association by special resolution, which would directly affect the rights of Mr. Zugani's shares. And Mr. Allen, who was acting on behalf of Mr. Zucani Estates, sued the company for alteration of the articles. And the question before the court was, is the alteration of the articles valid if it hurts the interests of some of the existing shareholders? Now, what the Court of Appeal did in this case was, right, they developed the so-called Allen versus Goldbrief test. And the question you ask, right, according to the court, is whether the alteration is reasonable and lawful. And how do we determine whether it is reasonable and lawful? Then you ask the question whether the alteration is done bona fide for the benefit of the company as a whole. It is lawful and reasonable, in other words, right, according to the court, the alteration or amendment, repeal of the articles is reasonable and lawful if it is done in the bona fide for the benefit of the company as a whole. So in other words, what you are looking at, right, is, for example, right, is there a commercial purpose for alteration or repealing of an article? Now, what the court said is, right, the test itself, okay, the test itself is legal, okay, the test itself is legal, but the outcome is factual. So in other words, in deciding, okay, whether it is bona fide for the benefit of the company as a whole, okay, it is a question of fact. But the test itself, okay, is legal. The outcome, okay, is factual. Now, but the question is, right, what if the company's interest is actually not engaged? What if the company's interest is not engaged? Now, of course, in a typical company dispute, okay, it is usually a dispute between majority shareholders and minority shareholders. Now, because majority shareholders who control the company would always argue that the alteration or amendment of the articles is in the interest of the company. And given that they have the majority votes, usually the alteration would be allowed. Okay? Usually they would follow the proper procedure, ordinary or special resolution, and the resolution will get passed, given the fact that they control the shares of the company. Now, does that mean that whenever they say it is in the interest of the company, then the alteration or amendment itself is lawful? Now, this was first illustrated in a case called Peter American Delicacy Company Limited versus Heath. Now, what happened in this case was there were two types of shareholder in the company. One group held fully paid shares, and the other group held partly paid shares. Okay, two types of shareholders: fully paid shares and partly paid shares. Now, traditionally, under the company's constitution, okay, it provided that bonus shares could be issued to all shareholders, regardless of whether their shares were fully paid or partly paid. Okay, that was the original clause in the Constitution. Okay, bonus shares could be issued to all shareholders, regardless of whether their shares were partly paid or fully paid. And as the facts turn out in this case was, the fully paid shareholders were the majority shareholders. Now, what then they decided to do, okay, the fully paid shareholders, they decided to amend the Constitution so that bonus shares could only be given to fully paid shareholders. Now, the issue before the court was, right, whether the act was bona fide in the interest of the company as a whole. So in other words, does the alteration here satisfy the Allen versus Gold Reef test? Right, so on the facts, right, we have two groups of shareholders, fully paid and partly paid. The articles originally provided that all shareholders, regardless of whether they were fully paid or partly paid, were entitled to bonus shares. Now, the fully paid shareholders, who also happen to be the majority shareholders, want to alter the articles whereby in the future only fully paid shareholders are entitled to the bonus shares. So the question before the court, is the alteration in the bona fide interest of the company as a whole? So does it satisfy the Allen versus Gold Reef test? Now, what the court decided was, right, even though the alterations affected the partly paid shareholders, on the facts, there was nothing to show that it was oppression or unjust. Okay? Even though the alteration affected the partly paid shareholders, who happened to be the minority, there was nothing to show that it was oppressive or unjust. And on the facts, the court decided that it was bona fide in the company's interests as a whole. Okay, on the facts, okay, it was bona fide in the company's interests as a whole. Even though, at the end of the day, the minority shareholders will lose out. Now, this was later further developed by the House courts in a case called Greenhalgh versus Arden Cinemas. Now, what happened in this case was, Mr. Greenhalgh was a minority shareholder in Arden Cinemas, and he was engaged in a battle to prevent a majority shareholder selling out the company, which he did. Now, as the facts turn out, the company had two classes of shares. One class was worth 10 shilling a share, and the other class was worth 2 shilling a share. Now, to cut a long story short, what happened was, right, Mr. Greenhalgh subsequently lost control of these shares, and he lost control of the company. And as the facts turn out, okay, the Articles of Association, a clause under the Articles of Association, provided that, quote, no shares in the company shall be transferred to a person not a member of the company, so long as an existing member may be willing to purchase such shares at a fair value. So in other words, what the Articles provided was, right, the existing shareholders have a right to first purchase the shares at a fair value before the shareholders can offer it to an outsider. Now, after Mr. Greenhalgh lost control of the company, the majority shareholders then decided to alter this term by a special resolution, okay, a three-quarter majority. And the alteration allowed existing shareholders to offer any shares to persons outside the company. Okay, so the original terms of the Articles, right? It must first be offered to the existing shareholders at a fair value. After Mr. Greenhalgh lost control, the majority shareholders then alter the article by a special resolution whereby all shares can be offered to outsider. Now, Mr. Mallet, who was one of the majority shareholders, then decided to transfer its shares to an outsider and wanted to resign from the board. And from Mr. Greenhalgh's perspective, right, if these shares were sold to an outsider, he would lose full control of the company. So what he did was, he tried to prevent this from happening and argued that the alteration was invalid. Now, what the House of Lords held was, Mr. Greenhalgh's claim, okay, does not have legal basis. Okay? The House of Lords held that his claim does not have any legal basis. Now, what the court held was, Mr. Greenhalgh lost control of his rights in the company as a matter of business, but not as a matter of law. Now, what the court said was, right, the first question you ask is, was the alteration legitimate? Okay, was the alteration legitimate? In other words, did the majority follow the proper procedure in passing that resolution? First one. Now, under the rules, right, what the court said was, right, all it required was to achieve a special a three-quarters majority to pass a special resolution, which the majority did. Okay, so all you needed to amend this article, a three-quarter majority, and the majority did just that, 75%. Okay, so point number one, it met the proper legal procedure. Now, another issue that the court had to answer was, right, yes, despite the fact that it did follow the proper legal procedure, so it was legitimate, okay, was it fair and reasonable? Was it fair and reasonable as far as Mr. Greenhalgh was concerned? Now, what the court held was, right, when a man comes into a company, he is not entitled to assume that the articles will never be altered. when a man comes in other words, when a man starts a business, a company, he is not entitled to assume that the Articles of Association will never be altered. Now, because what the court said was, right, Mr. Greenhalgh simply lost his control, okay, as a matter of business. There was nothing unlawful with that. So in other words, if the majority, okay, according to the court, right, if the majority follows the proper procedure and alter the articles, okay, that by itself, okay, is not a ground for complaint. Because when you start a company, you cannot expect that the company's article will never be altered. The fact that the alteration is against your interest, in this case against your economic interest, okay, that is a different matter. Now what the court said is, right, so long as the alteration does not unfairly discriminate, okay, so long as the alteration does not unfairly discriminate, okay, then we can perceive that this resolution was bona fidely passed. Now, of course, you might argue that, right? You might argue that, right? So, does it mean that whenever the majority shareholders pass a special resolution, which they can, providing that they control the company, does it mean that whenever they come up with the phrase bona fide in the interest of the company, then the alteration itself is lawful? Now, what a lot of scholars have argued, right? That test itself, okay, is too liberal in the interest of the majority shareholders. Now, because according to Greenhalgh, right, number one, all you need to show, proper procedure. Legitimacy, okay? Which is fairly easy to achieve, a 3/4 majority, providing you control the company. And all you need to argue before the court is it was done in the best interest of the company, in good faith. And that it has in other words, it has a commercial purpose. But it asks yourself this question: what action of a company does not have a commercial purpose? What action of a company does not have a commercial purpose? Now, supposing the majority of the company, right, come up with a statement that says, I want to gain control of the company, okay, for controlling purpose. Now, is that a commercial purpose? Well, it is. Can you argue that it is in the best interest of the company? You can. What if the majority says, I want to gain control of the company so that management can be much easier? Is that for commercial purpose? Well, yes, it is. So does that mean as a minority shareholders, there is nothing you can do? Now, as we'll look at later on, right? When we look at shareholders' remedies, okay? When we look at shareholder remedies, okay? Sometimes these are the grounds when minority shareholders may bring legal action against the majority shareholders. For example, oppression. Okay? For example, right? If you alter the articles, right? Is that seen as an oppressive act on the minority shareholders? Again, that's something we'll look at. Or does this alteration provide a ground for minority shareholders to bring what we call derivative action? Again, these are something that we'll look at when we look at shareholder remedies. But for the current purpose, okay, all you need to know at this stage, right, alteration of the company's article, right, must meet the Allen versus Goldrich test, which is bona fide in the interest of the company as a whole. Okay, bona fide in the interest of the company as a whole. The test is legal, but the outcome is factual. In other words, whether it is in the interest of the company as a whole, it is a question of fact. Okay, we'll take a short break. We'll come back in 2 minutes, okay?